Hi everyone, I'm Stephen. I'm a former prosecutor with the United States Attorney's Office for the District of Columbia. So friends, DC Federal District Court Judge EMTT Sullivan seems to have taken deadly seriously the word transparency as that word appears in the federal law, that is the Epstein Files Transparency Act. And Judge Sullivan just ordered Acting Attorney General Todd Blanche actually be transparent to comply with that federal law after finding Todd Blanche violated that federal law. We've got us a big legal development, my friend, and former fellow MSNBC legal analyst Katie Phang just won a significant victory in court. A victory for the rule of law, a victory for the American people, and perhaps most importantly, a victory for the victims of Jeffrey Epstein's crimes and the victims of the crimes of all of the people who were complicit in Jeffrey Epstein's and Ghislaine Maxwell's sex trafficking ring. Let's start with the new reporting. This from Politico, headline, Todd Blanche conceded violating law. On Epstein files, judge finds, and that article begins. The Justice Department has effectively conceded it is violating the law Congress passed last November, requiring the public release of the vast majority of records relating to convicted sex offender Jeffrey Epstein. A federal judge declared Thursday. U.S. District Judge EMTT Sullivan said Acting Attorney General Todd Blanche essentially admitted the violations by failing to address allegations from independent journalist Katie Phang in a lawsuit seeking broader access to the records, including allegations against President Donald Trump. This quote from Judge Sullivan, quote, "The Attorney General does not respond substantively to any of these arguments." Judge Sullivan, an appointee of President Bill Clinton, wrote in the opinion, quote, "The Attorney General has conceded that he is in violation of the Act." Sullivan also issued a preliminary injunction that gives Blanche a week to release certain names and other information redacted by DOJ from the millions of pages of the Epstein files, or provide a more detailed explanation for withholding them. Records subject to Sullivan's order include notes of FBI interviews with a woman who has alleged that in the 1980s, when she was about 13, Epstein introduced her to Trump, who in turn assaulted her, an attorney for Katie Phang. Brandon Bellalou said the ruling Thursday was the logical result of DOJ's cavalier response to the suit. Quote, "The government DOJ ignored its own law and blew off a judge's order, all for the sake of protecting the very powerful and the very rich." Bellalou said, quote, "Doing so had consequences. And now the public will finally get transparency around Jeffrey Epstein and his network." Okay, friends, let's cut right to the chase. I've got Judge Sullivan's 48-page opinion here. There's a lot in there, but I want to read a few select passages so you can get a sense of not only what Katie Phang's claim is all about, what this litigation involves, but it will give you a little flavour of how Judge Sullivan went about resolving these issues in Katie Phang's favour, and I would argue by extension in the American people's favour and in the victim's favour, and against Todd Blanche and his dirty DOJ. Underlings in the case of Katie Phang, plaintiff versus Todd Blanche in his official capacity as Acting Attorney General of the United States. Defendant memorandum opinion responding to public demands for information. Congress with near unanimity passed the Epstein Files Transparency Act on November 18th of 1925, which President Trump signed into law on November 19th, 2025. The Epstein Act is an unprecedented disclosure law requiring the Attorney General, with few exceptions, to make publicly available in a searchable and downloadable database all unclassified Department of Justice files related to its investigation of the notorious sexual predator and child sex trafficker Jeffrey Epstein, the child sex trafficker Ghislaine Maxwell, and their associates. The Epstein Act required extremely timely compliance. The Attorney General was required to make the information publicly available by December 19, 2025. The Attorney General made productions on December 19, 2022 and 23, and January 30th. Following the production of approximately 3.5 million pages of documents, the Attorney General announced that the department had complied with its production obligations under the Epstein Act on January 30, 2026. Katie Phang brings this action against Todd Blanche in his official capacity as Acting Attorney General of the United States, claiming that he has improperly withheld information and failed to comply with other requirements in violation of the Epstein Act. Pending before the court is Ms. Fang's motion for preliminary injunction, in which she seeks relief for a limited list of violations of the Epstein Act. Upon careful consideration of Ms. Fang's motion, the Attorney General's opposition, the reply, the applicable law, and for the reasons discussed below, the court grants Ms. Fang's motion. Friends, jumping forward to page 13. Ms. Fang seeks the information that she claims has been illegally withheld because as a journalist covering the Epstein story, she owes her audience, the public and the victims of Epstein, Maxwell and others, the most accurate and comprehensive reporting possible. The Attorney General's illegal conduct has injured and continues to injure her by preventing her from conducting the comprehensive reporting she would otherwise conduct about the specific information she seeks to obtain through her motion. Additionally, she states that the Attorney General's illegal conduct has caused and continues to cause her to suffer direct financial losses by constraining her ability to report on the Epstein files. Jumping to page 21. Ms. Fang likely has suffered a cognizable formational injury. It is well settled that a denial of access to information qualifies as an injury. In fact, where a statute on the claimant's reading requires that the information be publicly disclosed, and there is no reason to doubt their claim that the information would help them. And now on to page 35. Ms. Fang is likely to prevail on her Administrative Procedure Act claims relevant to the pending motion. Ms. Fang argues that she is likely to succeed on the merits of her APA claims relevant to the instant motion. Ms. Fang identifies 5 categories of violations of the Epstein Act. First, the Attorney General has violated the Epstein Act by redacting the names of senders and recipients in at least 8 email exchanges with Mr. Epstein regarding a torture video, sexual activity with young women, including minors. Second, the Attorney General has violated the Epstein Act by redacting the names of co-defendants in a draft indictment, the names of individuals identified as co-conspirators, and the sender and recipients in a department briefing email. Third, the Attorney General has violated the Epstein Act by withholding certain materials mentioning President Trump, specifically notes from FBI interviews with a victim who has alleged that in the 1980s, when she was about 13 years old, Epstein introduced her to Trump, who in turn assaulted her. Fourth, the Attorney General has violated the Epstein Act by not reviewing or producing any foreign language materials. And fifth, the Attorney General has violated the Epstein Act by failing to publish any redaction logs. And now, friends, page 45. There is no competing harm to the government, meaning to DOJ. If the judge grants this preliminary injunction, there is no harm to the government. With the issuance of preliminary relief that orders compliance with statutes and the Constitution, while there is substantial public interest in having governmental agencies abide by the federal laws that govern their existence and operations. And friends, after ruling in Katie Fang's favour and issuing the preliminary injunction Katie sought, the court indicates on its final page, the court will not issue a stay, meaning a temporary pause in DOJ having to comply with the court order. The Attorney General requests a stay of 7 days to determine whether to seek emergency appellate review. The Attorney General also requests a stay of 60 days to determine whether further appellate review is warranted. The court will not issue a stay for the reasons stated in the memorandum opinion. The Attorney General has conceded that he is in violation of the Act. Ms. Fang is not requesting the immediate production of documents, but rather that the Attorney General show cause if he declines to do so, meaning if he declines to produce the documents and otherwise comply with federal law. And that's the name of that tune, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.